One punch can land you with 4 completely different criminal charges. The difference between them could mean 6 months or life in prison, so let's climb the ladder and find out exactly how. We're looking at the hierarchy of non-fatal offences against the person. Picture a ladder. At the bottom, the least serious, a threatening gesture. At the top, the most serious, intentional grievous bodily harm. Each rung adds something, more injury or more culpable intent. We'll build from the bottom up. Let's start at the very bottom rung. Assault. This is a common law offence charged under the Criminal Justice Act 1988. Despite the name, assault does not require any physical contact. It's committed when a defendant intentionally or recklessly causes the victim to apprehend immediate unlawful force. The key case is R.V. Ireland and R.V. Burstow from 1997, where the House of Lords confirmed that even words alone, including silence in a phone call, can constitute an assault if they cause that apprehension. The victim must genuinely believe force is coming, and it must be immediate. So if you raise your fist at someone who thinks you're about to strike them, that's assault. Maximum sentence, 6 months. One rung up, battery. Again, a common law offence under the 1988 Act. Battery requires actual physical contact, the intentional or reckless application of unlawful force to another person. Crucially, no injury is required. The slightest touching can be a battery if it's unlawful, though the courts have carved out a principle of implied consent for everyday contact. A tap on the shoulder on a crowded bus is not a battery. The classic authority is Collins v. Wilcock, 1984, where a police officer's unlawful grip on a woman's arm was held to be a battery. Note, you can commit a battery through an indirect act. Throwing an object at someone counts. Maximum sentence, 6 months. Moving up to Section 47 of the Offences Against the Person Act, 1861, assault occasioning actual bodily harm. This builds directly on assault or battery. There must first be an assault or battery, and it must occasion, meaning cause, ABH. ABH was defined in R.V. Miller, 1954, as any hurt or injury calculated to interfere with health or comfort. That is a low threshold. Bruising, scratch marks, even significant psychological harm qualifies after R.V. Chan-Fook, 1994. Confirmed psychiatric injury can be ABH, though not mere emotion. The mens rea point is crucial and often examined. The defendant only needs the mens rea for the assault or battery. They do not need to foresee the ABH itself. This was settled in R.V. Roberts 1971 and confirmed in R.V. Savage 1992. Maximum sentence, 5 years. Rung 4. Section 20 of the 1861 Act, unlawful wounding or inflicting grievous bodily harm. 2 ways to commit this: wounding or inflicting GBH. A wound requires a break in the continuity of the whole skin. Both the dermis and epidermis must be broken, so a bruise, however severe, is not a wound. JJC v. Eisenhower, 1983. GBH simply means really serious harm. DPP v. Smith, 1961. The key word is maliciously, which the Court of Appeal in R.V. Cunningham, 1957, interpreted to mean the defendant must subjectively foresee some harm, not necessarily serious harm, to the victim. This is the crucial distinction from Section 18. Under Section 20, recklessness as to some harm suffices. Maximum sentence, 5 years, the same as Section 47, which surprises many students, but Parliament has never updated the 1861 Act. At the very top of the ladder, Section 18, wounding or causing grievous bodily harm with intent. The actus reus is identical to Section 20, a wound or GBH, but the mens rea is completely different and far more serious. The prosecution must prove specific intent. The defendant intended to cause grievous bodily harm, or intended to resist or prevent the lawful apprehension or detainer of any person. Recklessness is not enough. This is a specific intent offence which matters for the defence of voluntary intoxication. If D was so drunk they could not form the intent, they may avoid liability under Section 18, though they could still be convicted of Section 20. The word cause in Section 18 is also broader than Section 20's inflict, but since RV Ireland, courts treat the two words as practically equivalent, maximum sentence, life imprisonment. This is the most serious, non-fatal offence. Here's your check for understanding. Dan headbutts Priya, splitting her scalp open. He claims he only meant to scare her. He never intended serious harm. Which offence is he most likely guilty of? A. Common assault. B. Battery. C. Section 47 ABH. D. Section 20 GBH or wounding. The answer is D. Section 20. A split scalp is a wound because both layers of skin are broken. JJC v. Eisenhower confirms that. Without proof that Dan intended to cause grievous bodily harm, Section 18 can't be made out. But Dan foresaw at least some harm. He was acting violently. So the maliciousness element of Section 20 is satisfied. So the ladder rises with injury and intent, assault, apprehension of force, battery, unlawful contact. Section 47, that contact causes ABH. Section 20, a wound or serious harm maliciously inflicted. And Section 18, the same acts, but with intent to cause serious harm. Nail the distinction between maliciousness and specific intent, and you've cracked the hardest exam point in this whole topic. Your modules, mapped to your uni. Explainer videos for every topic. A tutor that knows your course. Essay writer for your essays and graded. Case briefs, flashcards, annotations. Try it free for 7 days. Link in the description.